Have you ever wondered what the difference is between a will and a living will? Have you ever wanted to know what a durable power of attorney is and when you might want to use it? Have you ever wondered what probate is and why people try to avoid it? If so, you're in the right place. Stay tuned for the answers to these questions and many more.
Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn.
Welcome to our episode on estate planning and its related documents. But before we begin, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. And don't forget to leave us your comments below. The first document we are going to discuss is a will, or as it is sometimes referred to as a last will and testament. The short explanation is that a will disposes of your property after you become deceased, which is a nice way to say when you are dead. More technically, the will appoints an executor who is the person who will manage the probate process, which requires various filings and distribution of assets to beneficiaries, among other things. The will should also include one or more successor executors who will step in if the higher tier executors are unable or unwilling to do the job. The will also describes who the beneficiary of the assets are. The next document we are going to discuss is a living will. A living will, or as it is called in some states, an advanced healthcare directive, is effective when you are alive but unable to express your own wishes with what to do with your body when you become sick. We are talking about whether you want to be on a ventilator or a feeding tube or those kinds of things. In the living will, you will make certain healthcare selections and appoint an agent to communicate these decisions to medical professionals. A durable power of attorney is effective while you are alive too. In the estate planning context, a durable power of attorney appoints an agent to manage your property when you are unable to make decisions for yourself. This could be because you're in a coma or have advanced dementia or similar conditions that impair brain functionality. The most nuanced and complicated of the estate planning documents is a trust agreement. Trust agreements can be used whether one is alive or when the person becomes deceased. In any case, trust agreements can be used to control disposition of property after the property owner is deceased, and is also used to avoid probate and sometimes to save on tax. Here, we will discuss revocable trust agreements. In a revocable trust agreement, you will appoint a trustee and successor trustees and designate beneficiaries and contingent beneficiaries. An example might be helpful here. Let's say I set up a revocable trust agreement for myself. I most likely will appoint myself as the initial trustee and beneficiary. My successor trustee might be my wife or my dad. My successor beneficiaries are likely some combination of my wife and kids. However, I could indicate in the trust agreement that my kids cannot take possession of the assets until they are 21, 25, 30, or some other age. You can also give the assets in certain percentages at certain ages. So I could give a third at the age of 25, a third at the age of 30, and a third at the age of 35. For people who have kids from prior marriages, trusts are much more common because they can be used to ensure that your children from that other marriage get a specified amount of assets so you don't have to rely on your current spouse to maintain a good relationship with that child and hope that the money gets to him or her. The other primary benefit of a revocable trust is that all of the assets held pursuant to the trust agreement will pass outside of probate. In other words, the trust agreement controls what happens to that property. Before we wrap up here, I want to give a very brief explanation of probate because it's confusing to many people. When someone dies and owns property, that property has to be transferred to other parties. However, the person who has the right to transfer the property is no longer available because he or she is dead. So the law says that the next of kin, if there is no will or executor, if there is a will, goes to the Register of Wills or whatever the agency is called in your local area, presents the original will and death certificate, and gets letters testamentary. Those letters appoint the executor with the authority to carry out the will, make all the necessary filings, which here we're talking about inventories, accountings, tax returns, and the like, and dispose of the assets of the decedent according to the terms of the will. If there is no will, the next of kin is appointed in similar fashion, but must follow applicable intestate law instead of the will. However, in either case, the decedent cannot control the assets after they are gone or after they become deceased. The assets are distributed, and that is that. A trust agreement will avoid the trust assets going through that probate process, and the trustee will automatically have authority to manage and dispose of the trust assets according to the trust agreement. As we discussed, the trust agreement could spell out the disposition of the assets decades or longer after the decedent has died. On that pleasant note, I hope you have enjoyed this episode on estate planning and its related documents. We have many more episodes on real estate and LLC topics, so please check them out. And please kindly don't forget to hit those like and subscribe buttons and leave us your comments below. With that said, thanks for watching, and I'll see you next time.